Hello friends, I am here today to teach you LLP Act 2008 and its silent features. The acronym LLP stands for Limited Liability Partnership Act 2008. I will not directly go into the concepts of LLP. What I will do, I will tell you short scenario of present time. A new trend has been observed during the last few months is that more and more entrepreneurs have started to opt for limited liability partnership. But question is that what is the Limited Liability Partnership Act 2008 and why it created? Before answering this question, I would like to explain the reasons behind emergence of LLP. Till few years back, there were only two forms of organization. Limited liability organization, that is companies, unlimited liability partnership, that is partnership proprietorship. Both these forms of organizations have their own plus and minuses. There is limited liability of the owners as compared to the partnership proprietorship, which are easy to form and operate, but small businesses and professionals usually tends to opt partnership or proprietorship as they are easy to form and operate. However, business grew, there was a need for a form of organization which was the hybrid between the two forms of organizations. Moreover, the rapid growth of service sector created an environment and demand for the new form of organization. Thus, the concept of limited liability partnership was evolved, which incorporates the benefits of both companies as well as partnership. As a result, LLP 2008 Act created. LLP is governed by the Limited Liability Partnership Act 2008, which has come into force with effect from April 1, 2009. The Indian Partnership Act 1932 is not applicable to LLP. What is LLP? What LLP is all about? The law defines LLP as a corporate business vehicle that enables professional expertise and entrepreneurial initiative to combine and operate in flexible, innovative and efficient manner, providing benefits of limited liability while allowing its member the flexibility for organizing their internal structure as a partnership. Now, I am explaining the term. A limited liability partnership, popularly known as LLP, combines the advantage of both company and partnership into a single form of organization. Limited liability partnership is a new corporate form that enables professional knowledge and entrepreneurial skills to combine, organize and operate in an innovative and proficient manner. It provides an alternative to the traditional partnership firm with unlimited liability. By incorporating an LLP, its member can avail the benefit of limited liability and the flexibility of organizing their internal management on the basis of mutual arrived agreement as in the case in a partnership firm. Need for LLP. As we know, new emergence must have some need, like that there is also huge need for creation of LLP Act. Under partnership law, the maximum number of partners a partnership firm can have is 20 only. And also the partners are liable jointly and severally, and most importantly the liability is unlimited, which means that the personal property of the partners can also be attached for the satisfaction of the debts in addition to the capital contributed by the partners in the firm. As I told you, not only are the firm's assets completely liquidated under the standard principle of the partnership law, but the partners are also jointly and severally liable for the entire liabilities of the partnership. Thus, this system acts as a deterrent for the growth and expansion of service-based organizations. This is the principal reason why partnership firms of professionals have not grown in size to meet the challenges posed today and the need for LLP aroused. Object of the Limited Liability Partnership Act 2008. Student, as we know that LLP is viewed as an alternative corporate business vehicle that provides the benefits of limited liability but allow its member the flexibility of organizing their internal structure as a partnership based on a mutual arrived agreement. Owing to flexibility in its structure and operations, the LLP is also a suitable vehicle for small enterprises and for investment by venture capital. How an LLP is formed? For forming an LLP, first we needed partner. There should be at least two persons. These partners can be natural or artificial to form an LLP. Here, artificial means any body, corporate or company. In case any body corporate is a partner, then he will be required to nominate any person natural as its nominee for the purpose of the LLP. These entities and or persons can become a partner in the LLP. Company incorporated in and outside India. LLP incorporated in and outside India. Individuals resident in and outside India. Process of formulation of LLP. Now, let's come to the basic process of formation of LLP. Before starting, you must go through the diagram. With the help of diagram, I tried to explain it into simple way. Capital contribution. Students, you must be noted that in case of LLP, there is no concept of any capital share, but every partner is required to contribute towards the LLP in some manner as specified in LLP agreement. So, the members contribute their capital as mentioned in LLP agreement, but not any rule has been made regarding their contribution in this act. Therefore, it is one of the advantages of LLP. The said contribution can be made in any form: tangible, movable or immovable or intangible property or other benefits to the limited liability partnership, including money, promissory note and other agreements to contribute cash or property, and contracts for services performed or to be performed. And the monetary value of contribution of each partner shall be accounted for and disclosed in the accounts of the limited liability partnership in the manner as may be prescribed. Designated partners. Now I will tell you about the designated partners. As per this act, every limited liability shall have at least two designated partners to do all the act under the law who are individuals, and at least one of them shall be a resident in India. Designated partner means a partner who is designated as such in the incorporation documents or who becomes a designated partner by and in accordance with the LLP agreement. In case of a limited liability partnership in which all the partners are bodies corporate, or in which one or more partners are individuals and bodies corporate, at least two individuals who are partners of such limited liability partnership or nominees of such bodies corporate shall act as designated partners. Designated Partners Identification Number DPIN. Every designated partner is required to obtain a DPIN from the central government. DPIN is an 8-digit numeric number allotted by the central government in order to identify a particular partner and can be obtained by making an online application in Form 7 to central government and submitting the physical application along with necessary identity and address proof of the person applying with prescribed fees. And it is not necessary to apply designated partner identification number every time you are appointed partner in a LLP. Once this number is allotted, it would be used in all the LLPs in which you will be appointed as a partner. Digital signature certificate. Now let's come to the other major feature of LLP formation. There are lots of forms required for the purpose of incorporating the LLP are filed electronically through the medium of internet. Since all these forms are required to be signed by the partner of the proposed LLP, and as all these forms are to be filed electronically, it is not possible to sign them manually. Therefore, for the purpose of signing these forms, at least one of the designated partner of the proposed LLP needs to have a digital signature certificate. I hope you are enjoying the topic. Now let's come to the some major salient features of LLP Act 2008. LLP Act and LLP name. The first and foremost feature of LLP is governed by Limited Liability Partnership Act 2008, which has come into force with effect from April 1, 2009. The Indian Partnership Act 1932 is not applicable to LLP. LLP is a body, incorporate and a legal entity separate from its partners having perpetual succession, can own assets in its name, sue and be sued. Ideally, the name of the LLP should be such which represents the businesses or activity intended to be carried on by the LLP. The Act has imposed an obligations on every LLP to suffix Limited Liability Partnership or LLP with its name. The clause also seeks to provide that no LLP shall be registered with an undesirable name or a name which is identical or nearly resembles to that of any other partnership firm or an LLP or a body corporate or a registered trademark or a trademark the application of which is pending. LLP agreement. Second most important feature of LLP Act is LLP agreement. So we can define LLP agreement as any written agreement between the partners of the LLP or between the LLP and its partner which determines the mutual rights and duties of the partners and their rights and duties in relation to that LLP. Let me tell you, for forming an LLP, there should be agreement between or among the partners. The said agreement contains the name of the LLP, name of partners and designated partners, form of contribution, profit sharing ratio and rights and duties of partners. You must be noted that it is not necessary to enter into an LLP agreement as per LLP Act 2008. In the absence of LLP agreement, the mutual rights of partners and in relation to LLP will be determined as per Schedule 1 of the LLP Act 2008. Partners and minimum number of partners. Students, the next feature of LLP is partners. Any individual or a body corporate may become a partner in a LLP provided the said person is of sound mind, is not insolvent and has not applied for adjudication for insolvency. Every LLP shall have at least 2 designated partners who are individuals and at least one of them shall be resident in India. If at any time the number of partners of LLP is reduced below 2 and the LLP carries on businesses for more than 6 months, the person who is the only partner of the LLP carries on business after those 6 months shall be liable personally for the obligations of the LLP incurred during that period. Designated partners. As I already told you that designated partner means a partner who is designated as such in the incorporation documents or who becomes a designated partner by and in accordance with the LLP agreement. Thus, every limited liability partnership shall have at least 2 designated partners who are individual and at least one of them shall be resident in India. In case if no partner is designated or if at any time there is only one designated partner, each partner shall be deemed to be designated partner of the LLP. In case of a limited liability partnership in which all the partners are bodies corporate or in which one or more partners are individuals and bodies corporate, At least two individuals who are partner of such limited liability partnership or nominees of such body corporate shall act as designated partners. The responsibility and liabilities of the designated partners are as provided. Responsible for the doing of all act, matters and things as are required to be done by the LLP in respect of compliance of the said act, and liable to all penalties imposed on LLP for any contravention of those provisions. Advantages of LLP. Till yet, we have talked a lot about LLP features, and I think all of you are now very much aware with the topic. So now let's discuss about some advantages of LLP. The process of formation is very simple as compared to companies and does not involve much formality. Just like a company, LLP is also body corporate, which means it has its own existence as compared to partnership. An LLP exists as a separate legal entity different from the lives of its partners. Both LLP and persons who own it are separate entities and both function separately. Liability for repayment of debts and law suits incurred by the LLP lies on it and not different from the life of its partners, the owners. LLP has perpetual succession. The LLP shall continue to exist till it is wound up in accordance with the provisions of the relevant law. LLP Act 2008 gives an LLP flexibility to manage its own affairs. Partners can decide the way they want to run and manage the LLP as per the form of LLP agreement. It is easy to join or leave the LLP, or otherwise it is easier to transfer the ownership in accordance with the terms of the LLP agreement. An LLP as legal entity is capable of owning its separate property and funds. Another main benefits of incorporation is the taxation of the LLP. LLP is taxed at a lower rate as compared to company. As a juristic legal person, an LLP can sue in its name and be sued by other. The partners are not liable to be sued for dues against the LLP. Under LLP, only in case of businesses where the annual turnover contribution exceeds rupees 40 lakh, rupees 25 lakhs are required to get their account audited annually by a chartered accountant. Thus, there is no mandatory audit requirement. In LLP, partners, unlike partnership, are not agent of the partners and therefore they are not liable for the individual act of other partners, which protects the interest of individual partners. Disadvantages of LLP. The major disadvantages of limited liability partnership are as: an LLP cannot raise funds from public. Any act of the partners without the other may bind the LLP. Under some cases, liability may extend to personal assets of partners. No separation of management from owners. LLP features in short. At end, I want to repeat some specific features of LLP in short. LLP is a body, corporate and a legal entity separate from its partner, having perpetual succession, can own its asset in its name, sue and can be sued. The partners have the right to manage the business directly, unlike corporate shareholders. One partner is not responsible or liable for the other partner's misconduct or negligence. Minimum of 2 partners and no maximum limit. Every LLP should have at least 2 partners with at least 2 individuals as designated partners, of whom at least one must be resident in India. Only designated partners are responsible for compliance with the Act. A firm, private company or an unlisted public company can be converted into LLP. The rights and duties of partners in LLP will be governed by the agreement between the partners, and the partners have the flexibility to devise the agreement as per their choice. The duties and obligations of designated partners shall be as provided in the law. Limited liability of the partners to the extent of their contribution in the LLP. No exposure of personal assets of the partners except in case of fraud. LLP shall maintain annual account. However, audit of the account is required only if the contribution exceeds rupees 25 lakh or annual turnover exceeds rupees 40 lakh. A statement of accounts and solvency shall be filed by every LLP with the Registrar of Companies ROC every year. The winding up of LLP is either voluntary or by the High Court. Difference between partnership firm and an LLP. Now, we will talk about basic difference between partnership firm and LLP. Features: registration, partnership firm. Not compulsory, unregistered partnership firm won't have the ability to sue. LLP. Compulsory registration required with the ROC. Name. No guidelines. Name to end with LLP Limited Liability Partnership. Ownership of assets. Partners have joint ownership of all the assets belonging to partnership firm. The LLP independent of the partnership has ownership of assets. Legal entity. Not a separate legal entity. A separate legal entity. Liability. Unlimited can extend to the personal assets of the partners. Limited to the extent of the contribution to the LLP. Number of partners 2 to 20 partners. Minimum of 2, no maximum. Foreign nationals as shareholders partners. Foreign nationals cannot form partnership firm. Foreign nationals can be partners. Annual return. No return to be filed with the registrar of firms. Annual statement of accounts and solvency and annual return has to be filed with ROC. Audit. Compulsory. Required if the contribution is about 25 lakh or if annual turnover is about 40 lakhs. Dissolution. By agreement of the partners, insolvency or by court orders. Less procedural compared to company, voluntary or by order of National Company Law Tribunal. So, these are the main differences between partnership firm and LLP. I hope you understand and enjoyed the topic. Thank you.